yesterday in depth. Ethics versus culture. You know the rules of ethics and law say that if I'm representing a corporation that's ripping you off and you're an Indian tribe, and you come to me and I'm the only lawyer that has an expertise in this area, I can't help you because it's unethical for me to help you. According to the rules of professional responsibility in law, there's nothing ethical about the Western rules of responsibility. The professional rules are designed to uphold corporate America. Everything, the law, the Supreme Court, even the way we run our tribes is designed to uphold corporate America. We work for the World Bank. The United States is owned by the World Bank. We borrow $1 to run our government services, and our unborn children will pay them back $3 after the interest is accumulated. How do we become an international actor, right? That's what we're here to do. You got to know who the enemy is. It's not each other.
So if all of the Indian people in the United States say, hey, the 1924 Act was illegal, I have never surrendered to be a U.S. citizen, then wouldn't that put you back in the international, you know?
There's only mechanism, because we're working within a protocol, a corporate protocol, and even the Seven Council Fires protocol is still valid under the rule of international law, except for what we voluntarily gave up, and we talked about that yesterday. We didn't give up nothing but some boundaries, and actually we didn't even give that up because we still maintain the collective rights with the other federally recognized Sioux nations within the 1851 territory. But let me answer your questions before you start adding more onto them, okay? Because we got to get through this. Ethics versus culture. Enforcement of rights. How do you enforce your treaty rights? Well, that's what we're here to talk about. And that's what you guys got to figure out. As you said, I'm going to give you some rules of law to work with. Something you've never probably had before to work with. And that's what we talked about yesterday. And we'll review it today. Come today, come tomorrow, come Friday, and you won't miss out on it anymore. But if you're coming in the middle of a conversation and expecting me to answer 13 hours worth of condensed 200 years law, I can't do it. I'm sorry. Law is culture. It reflects culture. It reflects yesteryear's culture. Right now, these judges are ruling against Trump because they're yesteryears, elected yesteryear. That's the culture they're reflecting, is yesteryears. We are relying on one white person to decide the fate of our sovereignty. And we're hoping they're going to be objective. We're hoping they're going to follow the rule of law. We're hoping we get a good attorney that can get the right things on the record. That's the wrong approach. That's our last card we play, not our first. Legal definitions, legalese. I'm going to keep using legal terms because we have to know what these terms are and what they mean when we communicate with legal professionals outside of our community. Especially state officials, it puts them on notice that we know what we're talking about. How do you know which law I'm talking about? You wouldn't unless you read them all or I specifically tell you. So ask me when I bring up. I know the gentleman over here back here, he's gone now. He didn't like the word Aboriginal title, Aboriginal rights I was using. That's not my word. That's the Supreme Court's word. It ties to the discovery doctrine, a very negative doctrine that gave Supreme Court jurisdiction over all matters in Indian country illegally. But with the discovery doctrine attached the concept of Aboriginal rights, which is still valid in the rule of international law. And what Aboriginal title says is we can't own land, so we can't sell it, but we collectively own everything on it, above it, and under it. So we collectively own all the minerals, all the natural resources. Ask a question if it's on point, but we're going on a tangent. Refrain and let's write it down and let's ask later.
Well, what came to mind was you talking about international rule of law. I was just, are you going to at some point talk about the Declaration of the Rights of the Indigenous People, how the United States is
I would
refused-
love to talk about that.
refused
And I think
to
that falls into
be-
more about tomorrow's discussion when we start talking about the laws of international and federal colonialism that we can use to our advantage, right? And I think that's the discussion you really want to hear. But I think in order to really be competent in that discussion, you have to know how we lost everything first. And you put the horse in front of the cart, it's not as efficient. So real quick inventory to the Constitution. Yesterday we looked at sovereignty as a bundle of sticks, right? And that bundle of sticks looks like this. And that's every right that a nation has. Every inherent power the United States has is right here. The right to make money, the right to have a military, the right to make treaties, the right to, protect their people. All these are inherent powers of every nation, right? And this is what we had coming into the 1851 treaty. The same rights as the United States on equal footing. That's why Article 6 is valid, because the treaty is still valid both in federal and international law. And because it's still valid, that means that when a U.S. official is not upholding the supreme law of the land, that's the highest violation on the planet. They're in violation of Article 6, and they're acting in their individual capacity, so sue them for everything they have. That's your Article 6 answer. So 1858 treaty, we come into 1858 treaty on equal footing. We haven't lost nothing. We haven't given up one inherent power. Now, like you said, you can tell the 1858 treaty, we broke it down yesterday and we did exactly what you did. You can tell by the tone and by the verbiage what was really going on, right? And you could see there was something very important for the Yankton people in there, because they actually expressed an inherent right. Instead of just saying we reserve all inherent powers, they said we reserve all inherent powers and the right to go in and collect our pipestone. That was very important.
It also said something about 51 treaty.
Yeah, it said everything will still be retained.
Right. So nothing was lost.
Well, and that's what we're getting into here, right? We have lost no rights coming into 1858, and we have lost no rights coming out of 1858. We still have all the rights as an international actor coming out of 1858 territory. Now, the rule of international law is if it's a contract, and if you're forced to sign out of coercion or duress, it's a void contract under rules of any jurisdiction.
I have another question about our comment in, I think